Morning everyone, and thank you for coming along to our webinar. As you'll see, originally it was about GDPR and Brexit, but we've added Schrems II into the mix because over the last week there's been a lot of developments in relation to that. So today I'll be hosting with Lauren, and I'm a partner in the Owen Mitchell data protection team. So for those of you who don't know me, I've been a data protection lawyer for an awful long time, over 20 years, and Lauren is also a specialist lawyer within the team. So we're going to be having a look, as I say, at the implications of Brexit for data protection and also what's happened in the last week or so in relation to Schrems. I think so. Just before we go into the main slides, just to let you know that we have got some information resources on our Brexit hub. So it covers more than data protection. So if you are interested in terms of advice on general Brexit matters, please do visit our Brexit hub, which covers a number of business areas such as employment and visas and things like that. So that's there. So in terms of what we're going to be covering today, if we can move to the next slide, and then the next one, please. I think it's fair to say that in 2018, data protection was very much at the forefront of people's minds. Everybody did a lot of work for the implementation of GDPR. Obviously, Brexit is now something that a lot of businesses are thinking about. While there's an awful lot of planning being looked at in terms of customs clearance and goods and things like that, I think it's probably fair to say that data protection is often overlooked in relation to a business's Brexit planning. Certainly data shouldn't be overlooked because according to some European Commission statistics, the data economy in the EU and the UK in 2020 will be around 440 billion euros. So it is a very large part of the economy, and it's crucial to this economy that data flows are preserved following Brexit. According to the news this week, it's a very important week in terms of the Brexit negotiations, and I think there are press releases out there that if any meaningful progress needs to be made this week in order for us to be able to achieve a deal by the end of the year. So it's very important for data protection that we have a deal, for the reasons that will become apparent later, particularly following the Schrems decision in the summer. So whilst I think it would be ideal to get a deal from a data protection point of view, I have to say my own personal view is I'm not really holding my breath on that. So on the basis that we don't yet know whether we'll have a deal, what we are going to be having a look at today is both what happens if we do have a deal and what happens if we don't get a deal. As I alluded to when I sort of did the initial introduction, originally we were going to just be talking about Brexit and data protection, but this week there have been some recommendations that have been issued by the European Data Protection Board and a new set of draft standard contractual clauses relating to data export, which we will also consider today. So as you'll see from the list, we've got quite a lot to get through in an hour, so it will be a bit of a canter through things. Obviously, if you've got any questions that we're not able to cover today, then by all means, if you could drop me or Lauren a line, that would be more than happy to come back to you. Or if you want to submit questions in the Q&A, again, if you can leave your name and details so we know who to go back to, that would be great. So moving on, the thing that we do need to think about today is the first point, which is whether or not GDPR will continue to apply. Certainly there's a lot of views, there are still a lot of views that GDPR will fall away once Brexit happens, and we'll be able to sort of use data as we wish, unfettered by GDPR, which is a load of red tape. That's not my view, that's general sort of things that we see kicking around. That's not going to be the case. GDPR is here to stay. And in fact, UK businesses may have to not only deal with GDPR that they're familiar with, but a UK version of GDPR. So at the end of the transition period, there will be this thing called UK GDPR, which is essentially the GDPR that we're used to, but with some tweaks to make it UK focused. Now, the reason that I say you could have to deal with both UK GDPR and EU GDPR, if we call it that for ease of reference, is that there is this thing called extraterritorial effect in relation to both of them. So what that means, moving on to the next slide, is that you are going to have to comply with UK GDPR if you're established in the UK. So a UK business established in the UK will have to comply with UK GDPR. If you're a business outside the UK, you will also have to comply with UK GDPR if you sell goods or services to individuals in the UK or monitor the behaviour of individuals within the UK. Equally, EU GDPR, even if you're not established in the EU, you will have to comply with it if you sell goods or services to individuals within the EEA, or if you monitor the behaviour of individuals within the EEA. And monitoring behaviour, there is some guidance in relation to this, if anyone is interested, issued by the European Data Protection Board, and it sets out what they consider to be monitoring. It is very much focused on electronic monitoring, but that's by no means exhaustive, and things like profiling, use of cookies in relation to customers and visitors to your website is something that could pull you within the extraterritorial effect of EU GDPR. So as I say, it may well be that you do have to comply with both. In broad terms, they are very, very similar, but there are some changes that we will have a look at later that might mean that you've got to update your documentation or look at some things around your privacy notices. But again, as I said, we'll have a look at those later. So the big issue, moving on, in relation to Brexit is the transfer of personal data in and out of the UK. So things will be quite easy if there is a deal, because certainly I know that data protection and the free flow of data is something that is the subject of negotiation. So it's not something that's going to get forgotten about if there is a deal. So if there is a deal, then we understand that it should be pretty much business as usual. So that makes life easy if there's a deal. If there is no deal, then that's where things get complicated. What we need to think about is what happens then. So from a technical point of view, if you're outside the EEA, you're a country outside the EEA, you're what's known as a third country. So for example, the US is a third country, and for anybody that's been trying to send data to the US, well, certainly for a long time, since the 1998 Data Protection Act at least and onwards, you'll know that you have to jump through additional hoops to get the data to the States. After Brexit, if there is no deal, we'll become a third country regardless after Brexit, but if there's no deal, we'll be in pretty much the same situation as the US. Also, from our point of view, under UK GDPR, the EU countries will be third countries. So what does that all mean? So that's all fine in terms of, you know, explaining the fine detail and legalities behind it, but what does it mean? So in terms of whether or not as a UK business you can continue to send personal data to EEA countries, yes you can. At the moment, the government has said that you can assume that there is a sufficient level of protection, you can continue to do what you're doing now. Can you continue to send personal data from the UK to countries outside the EEA? Well, the position won't have changed. So any country that has a finding of adequacy, and a finding of adequacy is essentially that it's been assessed by the European Commission and they are providing essentially equivalent protection. It doesn't have to be bang on the same as GDPR, but equivalent protection to GDPR, then you can continue to export. So any of those countries which have got a finding of adequacy, that will be replicated post-Brexit and you can continue to send personal data to those. So countries like Japan, Argentina, Israel, New Zealand, there is a list which is available on the ICO website. In terms of places like the US, then the position won't be changed by Brexit. Essentially, you will still have to jump through the hoops that you need to jump through to send it to places like the US. Schrems II, which is a decision that happened in July, has made life a bit more complicated in that respect, and we will have a look at that, because obviously if we are going to be in the same position as the US if there is a no deal, then we do need to understand in detail what Schrems II means following Brexit. If you are therefore wanting to get data from the EEA, so you're wanting an EEA business to be sending data to the UK, if there's a deal, that's fine. If there's no deal, then essentially we are in the same position as the US, as I say. Hoops will have to be jumped through, and we'll have a look at those in a minute. In terms of can you receive personal data as a UK business from outside the EEA, well, again, that will depend on the laws of those individual countries, and it may well change. In some of the countries they may be less keen on sending personal data to the UK. Once we're outside the EU, there may be no difference, so it is very much driven by what their laws are going to be. So moving on to have a look at what the options are if we are treated in the same way as the US, and essentially you want an EEA country to send personal data to your UK business. Well, what are the things that you might need to think about? So the first is it would be okay if we had a finding of adequacy. There are also certain safeguards that you could apply to the personal data, which are set out in Article 46 of GDPR, and there are some derogations which are in Article 49. Derogations are essentially exemptions. The one thing I'll say about derogations, even before we get to them, that they are not meant to be used for regular ongoing transfer of personal data. They're meant to be more ad hoc, and they are very limited. You are meant to read them in a very limited way in terms of the scope, has to be construed in a limited way. So looking at the issue of adequacy in the next slide, then essentially the UK government has nailed its colours to the mast and has said it wants adequacy. Now, adequacy decisions, for anybody that's been familiar with those, will know that they don't happen very quickly. It usually takes around 3 years for an adequacy decision to be given, not least because there has to be a detailed review of the legal system of the country to make sure that it provides appropriate and equivalent protections to the personal data as it would do in the EEA. Now, obviously, in terms of where we are, and we don't currently have an adequacy decision, the likelihood of getting an adequacy decision by the end of the year, I think, is very much going to depend on whether or not we end up with a deal. Because if we don't end up with a deal, then I think that is not going to happen. Also, I don't think things have been helped by, as I say, one of the things that gets taken into consideration for an adequacy decision is what the laws of the country who is seeking adequacy are in relation to personal data. Now, I'm sure that a lot of you will be thinking, well, we've got GDPR, we've had GDPR since 2018, why would we not get adequacy? Well, one of the things that does get taken into consideration is what access the security services have to personal data. And there was a recent decision in October, so just last month, in relation to the security services surveillance that's carried out both in the UK, Belgium and France, and the view of the court was that all of those countries went too far and it wasn't proportionate in terms of what they considered necessary under EU law. So this level of security services surveillance is not going to help in terms of any decision of adequacy. So unless we get a deal, I wouldn't be holding your breath on adequacy happening anytime soon. Which means, moving on, that if we don't have adequacy, do we have to put in place additional safeguards? Do we have to rely on derogations? So in terms of the order with which you should look at stuff, and this is something that has been issued by the European Data Protection Board, one, you start when you're exporting personal data looking at adequacy, and then you look at the safeguards, and then you only go to the derogations, which are the exemptions, if you can't make any of those work for you. On the slide, you'll see that there is a list of certain safeguards. It's not complete. There are some others, but these are the ones that are most likely to be used by businesses. There are some which relates to public sector. So standard contractual clauses There are a set of clauses which have been approved by the Commission, and also the current sets have been approved by the ICO, and essentially you sign them and you, with the person that you are exporting the data to, and essentially they put some guarantees in place in relation to how the personal data is going to be handled from a compliance with law's point of view in the protection, and they are really very popular. An IEPP, so IEPP is a privacy organisation, did a survey and found out that 88% of data export is done on the basis of standard contractual clauses. Unfortunately, standard contractual clauses previously used to be signed, stuffed in a drawer, and nobody ever used to look at them. That approach has been dealt a bit of a blow by the Schrems II case, which we will have a look at. And using standard contractual clauses for data export is now trickier than it once was. The other thing I will flag that we are going to have a look at today is the new sets of standard contractual clauses. They're in draft, and Lauren will talk about those later. But there are 4 new sets of standard contractual clauses. The other ones that you'll see on the list, which potentially can help legitimise any export of personal data, are binding corporate rules. That's intra-group. So you only use those for group transfers. They're not easy to get and they're not quick to get. So if you don't have binding corporate rules already in place, then getting binding corporate rules to allow you to export or to import, personal data from the EEA by January is not going to happen. So the other 2 at the bottom, which are compliance with a certification scheme or a code of conduct, I have flagged them and they're not yet in place, but I was listening to something that the EDPB, the European Data Protection Board, were talking about last night, and they were sort of again saying that they are coming, that they are working on them. So whether or not that's something that might be rushed through to try and help with the difficulties posed by the Schrems decision, I don't know. But certainly it's worth watch this space. I think 2 things that are probably worth mentioning in relation to exporting personal data and the safeguards is first, as I say, binding corporate rules apply to group transfers. Intra-group transfers are also caught by the rules relating to data export. So don't think just because you're sending it within the group that you don't have to abide by those. And the other thing is, in terms of what data export is, then access to personal data from outside the EEA, even if essentially it's not transferred, in terms of you don't send a data file outside the EEA, is still regarded as export, and that is something that the European Data Protection Board in its recent recommendations has made clear, because there is, I often have people telling me that they don't have to worry about data export because whilst it might be accessed from, for example, the US, it's not actually, you're not sending a data file to the US, so there's no proper export. But that's not the case, and that is still regarded as export. So moving on to the derogations themselves, as I say, I am not going to spend a lot of time on this because we really are pushed for time with the amount of stuff we have to cover, and also they are things which, 1, should be used as a last resort, and 2, shouldn't be used for an ongoing transfer of personal data. So I've talked a lot in this first part of the webinar about the Schrems decision, and I'm sure that some of you will know about it, some of you may well not know about it. So what we're going to do is recap on what happened with the Schrems decision, and then we're going to have a look at what the practical impact of that is, and what, as I say, in the last week or so, the European Data Protection Board has got to say about that, and whether or not that helps businesses to try and navigate the implications of Schrems. So I'm now going to hand over to Lauren, and she's going to talk about what happened with Mr. Schrems and his court case against Facebook.
Thanks, Joanne. Before I start, can I just say there is a feedback form on the Q&A, so we would be grateful if you could fill that in either at some point during the webinar or following the webinar, then that would be greatly received. Thank you. So just as a kind of a quick look at Schrems, as Joanne's mentioned, there's a lot to cover in this, and I'm sure some of you will have seen the news already. So we have the judgment in July this year in relation to Schrems II. So this is the latest challenge in the which was issued in the Irish High Court by the Data Protection Commissioner against Facebook Ireland. So this was a continuation of the original Schrems case, which meant, some of you may remember, found that the safe harbour regime, which previously had allowed for the transfer of personal data between EU and the US, that was found invalid in 2015. So this was a continuation of that case. So it called into question the lawfulness of Facebook Ireland's transfer of the EU citizens' personal data to Facebook Inc. in the US on the basis of standard contractual clauses. So in May in 2018, the Irish High Court referred the question to the CJEU. And there are essentially 11 questions which the High Court queried. These included whether the Article 45 finding of adequacy is relevant to the assessment of the validity of standard contractual clauses as an appropriate safeguard under Article 46, whether the Ombudsman mechanism under the Privacy Shield provided an adequate remedy to data subjects. So that was kind of one of the questions in relation to Privacy Shield. So it's probably worth mentioning that actually the initial kind of case was brought about in relation to transfer of on the basis of standard contractual clauses. So Facebook weren't actually using Privacy Shield at that time, but there was kind of a question as if, well, if Privacy Shield allowed for inadequacy of transfer to the US, then that essentially would mean that the standard contractual clauses was adequate. So moving on to the next slide. Like I mentioned there were two questions in relation to Privacy Shield, one of which being in terms of the Ombudsman. So the Court of Justice of the European Union held that the US had no guarantee of equivalent protections of data subjects' rights to personal data to the EU because of access by the US surveillance authorities of personal data. That the US law does not set out an effective limitations on the power of intelligence services. So on the basis of that, it found that Privacy Shield was declared invalid. However, it did go on to say that the standard contractual clauses were still valid, but it was subject to a number of additional conditions. So as Joanne's already mentioned, there was this kind of thought, and practically a lot of people were just signing the standard contractual clauses and then they were being put in a drawer. And I think for a lot of people, obviously, there was a number of obligations that were set out in the standard contractual clauses, but these weren't necessarily being followed. They were being kind of forgotten about. So the basis of the judgment in relation to the standard contractual clauses was that they would remain valid, but there's more onerous that they had to be followed and that obligations had to be carried out. So they had remained valid subject to the test in Article 46. And like I said, it's not new requirements. It commented that the adequacy test should mirror the adequacy test in Article 45. So whilst they were initially set up as standard contractual clauses, there's now the judgment kind of put in place this idea that if you're using standard contractual clauses, there should be kind of a higher level of adequacy. So in terms of that, it also mentions that the exporter should be carrying out a risk assessment and due diligence in terms of the country that it's exporting to. So you can't just put in place the standard contractual clauses whenever sending personal data outside the EEA, and that would be sufficient. You would need to think about what country is it being sent to, where is the importer based, and the rules and the surveillance laws that are in place there, and then thinking about the obligations within the SCCs and whether they can be complied with. So that's kind of just a quick kind of overview of the Schrems II decision, and then I'll hand over to Joanne to show how that's kind of been discussed following that decision in July.
Thanks, Lauren. As Lauren said, obviously that case related to the export of personal data to the US. But from a Brexit point of view, if we end up with no deal, as I've said, we will be in the same position as the US. So people wanting to send personal data from the EEA to the UK will have the same things to grapple with as export from the EU or the UK to the US. So what's happened in the last week is that the European Data Protection Board, which is the pan-European regulator, has issued some recommendations. Now, you have to be very careful, and I have called them recommendations. I hadn't realised until I was listening to the European Data Protection Board speak about it last night that there was code in them calling them recommendations. So they're not law. They're very keen to point out they're not law, but they're not guidance either. They are recommendations. And what they mean by recommendations is that they're one step up from guidance in terms of they have to carry more weight. They do carry more weight. So you don't technically have to do what they're telling you in the recommendations because it's not law, but I think you have to have either a good reason not to follow them or a high tolerance to risk if you've decided that you think your export is protected even though it's contrary to the recommendations. What the recommendations are there for is to try and plug the gap. So as Lauren said, when you are trying to use certain types of export, so originally in the Schrems case, standard contractual clauses, you have to do an evaluation of the legal system that you're wanting to export to. And if that's problematic, is there any other way that you can plug the gap and put in place some safeguards that mean that notwithstanding the fact that the legal system is problematic, you can put protections in place, which means you can continue with the export nonetheless. So moving on, what the recommendations have done is that there are 6 steps. If we can move to the next slide, I've set out the steps over the next 2 slides. So step 1, which is fairly logical, is that you need to know your transfers. So you need to know what data is essentially going out of the EEA. So what data are you wanting to receive from a Brexit point of view from the EEA? Now, if you are exporting, so potentially if you are looking at exporting to the US, I'll just throw this in there while it's not strictly Brexit related, not only do you need to know what your immediate people that you're contracting with in terms of suppliers are doing, but they've also made the point that you need to know about any sub-processors. So any subcontractors to your supplier that will be processing your business's personal data, you need to understand all of those data flows. What the European Data Protection Board have said is that they think this is fairly easy because you should be able to build on your Article 30 register. So for those businesses that spent a lot of time in preparation for GDPR putting together a really good Article 30 register, you'll be one step ahead in terms of following the 6 steps that the European Data Protection Board want you to do. Once you know what your transfers look like, then what has to happen next is a consideration of what legal safeguard you are going to use. So if you are sending to a country that has an adequacy decision, then that's fine. You don't have to go through the remaining steps. If, however, you are going to be using standard contractual clauses, BCRs, and terms and binding corporate rules, certification codes of conduct, then you do need to go on to the next step. Just throwing in there the Article 49 derogations, again, you don't have to move on to the next steps if you're using those. So it's essentially standard contractual clauses, binding corporate rules, certification, codes of conduct. One thing I will throw in there about adequacy, though, that they have put in their recommendations is that you need to check periodically that adequacy is still in place. So if you are exporting to a country, so for example, looking at your export rather than necessarily the full Brexit implications, if you're sending stuff to Argentina, you need to periodically check, for example, that Argentina does still have adequacy. Step 3, if you've decided that what you're going to do is you're going to use standard contractual clauses. So you're going to bring the data on shore from the EEA and you're going to use standard contractual clauses, what happens next? So there has to be an assessment of the country where the personal data is going into to see whether or not it essentially offers equivalent protection. Now, this is a mini adequacy assessment. It's not easy, and it requires you to understand what protections are given to personal data, what redress individuals have in relation to misuse of the personal data, and importantly, what the security services can do in terms of accessing personal data. Now, you can appreciate that if you are sending your personal data to countries you are not familiar with, in terms of the legal systems you're not familiar with, this can be quite a difficult job. And certainly, I think if we're looking at you exporting from the UK to countries outside the EEA, then this is something that you're probably going to need help from your supplier with in terms of what the legal rules are. If we look at it from a Brexit point of view, and we're looking at the importation of personal data from the EEA to the UK, then essentially it means looking at the UK's rules. Now, obviously, in terms of protection of personal data, as I said earlier, we've got GDPR. The problem is the security services ability to access personal data, which, as I've said, has already been something that the European Court looked at last month. Now, I'm not saying that that will definitely mean that personal data cannot come into the UK. I'm just saying that in terms of the assessment, it is something that will need to be thought about. In terms of looking at that, what you need to do is to have an understanding of what, for example, the security services can access, because if the laws relating to security service access doesn't apply to your personal data, then that decision of the European Court in October may not be a problem for you. It is something that needs to be thrown into the whole mix of the assessment of the legal system. So if you've then assessed the law, if you think that equivalent protection is okay and it is there, then you don't have to look at the supplementary measures. If, however, the country concerned essentially causes a problem from the does it offer equivalent protection to GDPR, then you need to have a look to see whether or not the gaps can be plugged. And this is step 4. And essentially in step 4, what the European Data Protection Board have tried to do to be helpful is that they've given a list of what suitable supplementary measures might be. Now, what I can say about the guidance, sorry, recommendations, don't call it guidance, is that it is very detailed. Some of it, when we have a look at what those supplementary measures might be, you might think are not very helpful. And certainly I think the European Data Protection Board sort of recognised that. And when I was listening to something they were talking at last night, they were sort of saying, don't blame us because we didn't make the law. We're just trying to sort of help in terms of provide detail. So we'll have a look at those in a bit more detail in terms of what the supplementary measures or the gap plugging is in a minute. But looking at step 5 and 6, if you find a supplementary measure that is going to help you, and one thing I would say is the supplementary measures are split into technical measures, so things like encryption, contractual measures, and also organisational measures in terms of how things are organised around personal data from a corporate point of view, for example. Only really the technical measures are going to help if the country's laws that you are exporting to don't provide equivalent protection when you've done your mini adequacy decision. So the others are really there to bolster the position when you're pretty much happy with the laws of the country that you're exporting to. So I think whilst there are details of contractual and organisational measures you can put in place, they're a lot less helpful than the technical measures that are there, which we will have a look at. Step 6 is that you do need to reevaluate the position at appropriate intervals, and I've put that in inverted commas because obviously what's appropriate is left to the business to work out. It does say in the recommendations that requires continuous vigilance. So again, it is going to put an obligation on the business, which isn't necessarily going to be that easy to deal with. And also, obviously, all of this will add to the expense involved in terms of dealing with the export of personal data, and certainly from a Brexit point of view, if we don't get a deal with the import of personal data from the EEA into the UK. So moving on, what we've got is on the next slide, you'll see that it references Annex 2 to the recommendations. And Annex 2 is where the examples are set out, where the European Data Protection Board thinks it's okay in terms of these are situations where even if the legal system might not be fully compliant with what we're expecting, you can put some of these protections in place, additional protections, and that will make the export okay. And also some examples of where they don't think it's okay. Now, from a timing point of view, we don't have time to go into detail into each of the scenarios that they have mentioned. So I would definitely recommend that you have a look at the European Data Protection Board recommendations if you do have time, and this is something that is important to you. You'll see in terms of areas where they think that they can help and that these additional things will bolster and plug the gaps of the legal system, and that's essentially where you've got hosting offshore, and the supplier doesn't need to access the personal data in an unencrypted form, so essentially you've used encryption. The data that's exported, if it's pseudonymized, that may mean that you can plug the gap, and by pseudonymized what I mean is that you take the identifiers off and you use something else. So whilst you may be able to put the data back together, if you are sending it to somebody offshore, if they only get the pseudonymized data, so for example you take my name, so you take John Bone off and you put a string of numbers instead, if they only get the string of numbers and they don't have enough information to match it back together, and they've got this pseudonymized data, for example for analysis is one of the things they suggest, then that may help. Also, if the data is only transiting a country outside the EEA and it's encrypted, that's okay. If the person that's receiving, or the entity that's receiving the personal data, has got special status or special protections under the laws. So for example, they give you an idea of if you are seeking medical advice or collaborating in relation to medical issues, or you're seeking legal advice, because if under the law of the country concerned those areas get special protection in terms of there is no requirement for disclosure, or there is additional protection given to the personal data as a result of those, then again that can plug the gap. The other one that they've suggested is if you split the personal data between different suppliers, so they get part of the data set and then the other supplier gets another part of the data set and then another supplier gets another part of the data set, because essentially you can't match it all back together, that may well provide sufficient protection. Moving on to the next slide, where we have a look at scenarios where the additional supplementary measures don't help. You'll see there that they mention cloud service providers who need to provide a service in relation to the data and therefore will need access to unencrypted data. And similarly, they're talking about intra-group transfers of, for example, HR or customer data. And again, it's not encrypted because it needs to be used by the recipient. And certainly these two are not particularly helpful, because this is certainly what a lot of people are doing. One of the questions we've been asked is, do all these rules apply to business data? Well, it certainly applies to business data, because GDPR is very clear that it applies to business data. One of the things we've also been asked is, well, what happens if it's just a name and or a business email address? Again, it is personal data and technically they do apply. Whether or not they would be the top of the ICO's list in terms of being concerned, probably not, but technically they will still be caught by this. And you'll see here that, you know, it doesn't distinguish between individuals, that's non-B2B. It is very much B2B data is caught by GDPR and by these rules in the same way. So moving on to the next slide, I'm going to pass on to Lauren, who is going to talk about the 4 sets of new standard contractual clauses that again came out in the last week. So Lauren.
Thanks, Joanne. So as Joanne said, it was a busy week last week. So on the 12th, so the end of last week, the European Commission published its draft implementing decision on the new standard contractual clauses. So this is something that's been long awaited, and I'm sure if you use standard contractual clauses, it's certainly the new version has been waited since GDPR came into effect in 2018. So it's probably worth mentioning that they are under a consultation period. So the consultation is open till the 10th of December currently. So the clauses try and reflect, which is what the new requirements, or the requirements under the Schrems II judgment, and many have said that's why there's probably been a delay in the new standard contractual clauses being released. And they help the transferring of data incorporate safeguards for the data transfers that go above and beyond the current standard contractual clauses. There is going to be a significant job for the parties, so whether you are a data exporter or a data importer, to move and transition over to the new clauses. So there is a 1-year sunset period, as they've called it, so which basically puts in place the new clauses. So during that period, the transfers can continue on the basis of the existing standard contractual clauses if you have them in place. So you would have to move if the contract changes. So if the contract changes, then the parties may lose the benefit of the sunset provision and must move to the new clauses. But however, if you are just adding in kind of additional safeguards to deal with the Schrems judgment and addressing kind of the known deficiencies, then you can continue on the current SCCs. Obviously, that being said, until the end of this kind of transition period. So one of the things that they have done is addressed the previous gaps, which I think that well known to everyone that these gaps were here for a number of years. It's definitely since essentially the previous SCCs were released. So for instance, they've kind of introduced more versions of standard contractual clauses. For those of you who previously used them, you'll know that there was only kind of a controller to controller or a controller to processor version, whereas now the new clauses have a controller to controller, a controller to processor, a processor to sub-processor, which is one thing that was lacking, and I think was something that a lot of people had to kind of grapple with how they were going to deal with that. If you had, say, for instance, a processor in the EU and a sub-processor outside of the EU. And then another thing that they've done is put in place a processor to controller. So for instance, if you have a processor based in the EU and a controller who they're essentially going back and reporting to, who's based outside of the EU. They have also stated that they can be used by parties that are not established in the EU. So for instance, if you have, as John's mentioned earlier on, that just because you're not in the EU or EEA doesn't mean that you're not caught by GDPR because of its extraterritorial effect. So for those kind of parties or controllers that were based outside of the EEA and are caught by the extraterritorial effect, then they can use these SCCs as well. So moving on to the next slide, just as a kind of quick overview of some of the things that have been put into the new SCCs. As mentioned earlier, the kind of main criticism for the SCCs, and which a lot of people practically were aware of, is that exporters and importers were just signing them and they were being kind of a paper exercise and being put in a drawer. Not saying that that's always been the case, but there was this common kind of conception that is what was happening. So they are drafted to take into fact the Schrems II decision, as I mentioned, and that being said, they have retained some of the principles that were in the previous SCCs that were considered positive. And essentially the points that made the SCCs remain as a valid transfer mechanism. So for instance, the obligation on the exporter to consider the level of protection in personal data in a third country. However, even though that obligation is on the exporter, practically it's going to need to be assisted by the importer. There's also, for instance, the obligation on an importer to notify the kind of part of the exporter of any ability to comply with the SCCs, and then a corresponding obligation on the importer to suspend that transfer or terminate the agreement if it has received that notice from an importer. And if it continues to transfer personal data having received that notice, then it would need to notify the supervisory authority. Some of the new clauses that have been introduced include addressing kind of enhanced transparency obligations, specifically in relation to the controller and kind of the controllers that are based outside of the EU, EEA, and how they would deal with transparency obligations. Also, in terms of, say, rights of access and rights of erasure. It doesn't go as far as to impart all of the kind of obligations. So in terms of portability, for instance, is not necessarily there. The exporter is also required to document transfer impact assessment it carries out and make this available to supervisory authority on request. Helpfully, it sets out things that need to be considered, such as considering the law and practice in a third country. So I think that's probably one thing to kind of note. It's not just specifically the law in a third party, but also the practice in a third party. Things such as the duration of a contract, the scale and regularity of transfers, the transmission channel used, and the type of recipient, for example. There's also stronger commitments on importers when they are faced with a kind of request from a public authority to see the information. So as obviously that was kind of the crux or something that came out of the Schrems decisions, and ultimately one of the concerns which led to the invalidity of Privacy Shield. So there is this kind of obligation on importers to question when they've been requested to see EU personal data by a public authority, and where possible, try and put in place interim measures, as well as only disclosing a minimum amount of personal data that's reasonable in relation to response to that order. They should also make sure that they're documenting and preparing a transparency report, which in relation to that that kind of request from a public authority. And finally, another kind of example, like I say, it's probably we don't have time to go through all the clauses in the SECs in this, but one of the other things noted is in terms of it's designed to be used by multiple parties and also to change over time, whether that's kind of adding new parties and changing parties. So this is done by a new kind of docking clause. Just before I move back to Joanne, who's going to kind of talk about the next steps, is actually we don't yet know the position from the ICO. Obviously, as we were saying, we're going through Brexit and what happens at the end of the transition period. The ICO has currently kind of just made a statement, and I've checked again this morning, and the statements, there's been no updates, that they're essentially reviewing the recommendations and the SECs that were released last week. And all they've said is they're reiterating their advice that businesses should take stock of any international transfers they make and then update their practices as guidance and advice becomes available. So I'm going to hand back over now to Joanne, who is going to deal with what happens if there is a no deal.
Just in terms of what you were talking about, Lauren, we've had a question about the practicalities of the standard contractual clauses in terms of, obviously, they're open for consultation. I think the consultation closes about the 10th of December. As to what should you do if you're trying to put some standard contractual clauses in place at the moment. Should you go with the existing ones? Should you wait and see what happens in terms of the new ones? What should you do? I think the other point on the standard contractual clauses in the consultation might end on the, I think it is the 10th of December, but I'm happy to double check that, is well, what if they don't get approved? Because they have to have implementing legislation from a European perspective to actually come into force. So if everybody's trying to prepare for Brexit now, and essentially by the end of December, if the consultation doesn't end until the middle of December, and then it's a question of do they need changing again, and when's the implementing legislation going to come in? Can you even use the new ones? And probably, I mean, we don't definitely know because we don't know, as Lauren said, whether the ICO will be happy with using them under UK GDPR. I suspect that the ICO will be okay with that because we need to align in terms of keeping our adequacy hopes alive. But from a simple timing point of view, can you just go for the new ones? Probably not in the time. I don't know. I might be wrong and they might go through really, really quickly. I think what I would probably say from a safe point of view is go with the existing ones if you've got a set that apply to what you're doing, and then update them with the new ones once the implementing legislation's happened, and also and obviously the consultation's closed, and also that the ICO said they're okay to go with, which I appreciate doesn't really help people with Brexit planning. But in terms of where we are in the year and with this, I just think it's probably unlikely. I don't know what you think, Lauren, in terms of it's unlikely that they're going to be done and dusted and ready for use in time to enable people to actually get them in place and deal with the additional detail in them ready for the end of the year.
Yeah, I think I would tend to agree, and I suppose what I would probably do to try and help capture that is actually think, obviously you've got the Schrems judgment from July, and you've got the additional kind of points that these new SECs have introduced in terms of how to carry out the risk assessment and the type of things to do. So if you're putting in the old SECs to get something in place pre-December or pre the end of the year, following the judgment back in July, there's already that idea that you need to be carrying out a risk assessment. So if you're using the old SECs, put in place your risk assessment using kind of the thoughts and ideas from the kind of the points that have been suggested, and then you kind of got a bit of a halfway house if you've already started to look at and put together, like I was saying in the earlier slides, like the type of transition, the type of personal data that's being used, what's the law, what's the practice in the area that you're transferring personal data, and the kind of, I know there's been a lot of commentary thinking about whether the importer you're sending to, have they previously had a request from a public authority? Is it something that's likely to be kind of requested? What is it, an at-risk area? So I think I agreed, John, with your points. I think to put something in place, and given where we are now in the year, I'd go with the SECs, but try and mirror some of those ideas with the new ones to essentially put yourself in a good stead for what happens next.
Yeah, no, I agree. I think if you get yourself a head start, I think timing wise, in terms of if we end up with a no deal and when Brexit happens and all these things that are happening from a privacy point of view, it does make life quite difficult. It's probably an understatement. Moving on, just quickly on some additional points that do need to be thought about. You'll see that we've said there's a double jeopardy. Obviously, if you are subject to UK GDPR and also EU GDPR, you could get fined under both regimes. Obviously, the fines are pretty chunky, so you do need to bear that in mind. If we move on to the next slide, you'll see that one of the things that is gaining traction, and I think businesses weren't really aware of it until recently, but we are seeing requests now in relation to representatives, in terms of if you're a UK business, you might need to appoint a representative in the EEA. And when that needs to happen is if you're caught by the extraterritorial effect. So as I said earlier, in terms of the extraterritorial effect bites, if you are selling goods or services to an individual, or if you are monitoring the behaviour of an individual in the EEA, which can be via online profiling or cookies and things like that, then you do need a representative, unless you can then bring yourself within the exemption. And the exemption is that your use of personal data is occasional. It's not large scale in relation to special categories, so like health data or religion or trade union membership, things like that, criminal conviction data as well. And it's unlikely what you're doing is going to result in a risk to the rights and freedoms of individuals. So if you're caught by extraterritorial effect and you're not within the exemption, you will need a representative, and your representative is there to deal with individuals, for example, those who want to exercise their rights, and also for liaison with the supervisory authorities. In terms of moving on, who you should appoint, then you need a representative who is based in one of the EEA countries, where you've got people whose personal data you're processing. Quite often people are looking for group companies to do it, but there are other external organisations that will do it for a fee. And if anybody wants to talk to me about potential representatives, then I'm more than happy to take it offline after this to talk about options in relation to representatives. The ICO in their guidance, notwithstanding the fact that I don't think UK GDPR requires a representative at the moment, has said that that will be sorted and a UK representative will be needed if you are an organisation, for example, who is based outside the UK but will be caught by the extraterritorial effect of UK GDPR. Moving on, the next implication that you need to think about from a data protection point of view, if we end up with no deal, is the end of the one-stop shop. So the one-stop shop, by that I mean is that at the moment there is somebody who will be a lead regulator if you have a problem. So if you have done something which potentially cuts across a number of jurisdictions within the EU, you potentially only have to deal with one regulator. If there is a no deal, obviously you potentially are going to have to, you'll be outside of the one-stop shop and may have to deal with multiple regulators, which will be a pain, not least because not all supervisory authorities and regulators take the same approach. Certainly it was very painful pre-GDPR and pre the one-stop shop. Moving on, something else that does need to be thought about is your documentation. In terms of what do you need to do? Well, you're going to have to look at your Article 30 record because you might need to update data export. So, for example, if you're caught by EU GDPR and you're exporting to the UK, that will need to be picked up, and also the lawful basis. So if you have said that you are processing, for example, an EU data subject's personal data based on compliance with laws, compliance with laws only applies under EU GDPR where the laws are those of a member state or those of the union. Once we're outside, if there is no deal and this isn't picked up, you can't rely on that because UK laws, we will not be a member state, and also we'll be no longer, you know, if it's not something under union laws, you can't use it. So you do need to have a look at where you've used compliance with law as a basis for the legal processing of personal data in your Article 30. That also impacts on your privacy notice because, as you'll know, anybody that's had to put together a privacy notice, which isn't the easiest of jobs, is that you do need to mention what your legal basis for processing the personal data is, and again, if it's compliance with law, you might need to look at that. And also you do need to mention what your data export position is, so that will need to be updated in your privacy notice. If you are required to have a representative, in terms of an EEA representative, you will need to put that in your privacy notice, and obviously if you're established in the EEA and you're required to have a UK representative, you'll need to update your privacy notice to deal with that as well. And data protection impact assessment, DPIAs. One of the things that is looked at in relation to a DPIA is data export, so that is something that does need some thought. So finally, I've tried to pick up some of the questions throughout, but I don't think we're going to get very long for questions. So if anybody, as I say, wants to leave their details, we can come back to you separately. But what we've done in terms of finishing off is to look at some practical takeaways from what we've said today. So I think the first thing is, I mean, obviously we're very close to the end of the transition period at the minute. Is at the moment you probably still can't pin your colours to a mast as to which one's going to happen. So I would continue with preparations for a no-deal Brexit, even if you think there will be a deal. The next one is, I think you need to understand your data flows. You need to understand your data flows anyway. And certainly if what you are going to do in order to bring data onshore from the EEA to the UK is rely on standard contractual clauses, which is probably going to be the easiest way to do it if you can make them fly, is you're going to have to understand your data flows from that. You need to be prepared, I think, in relation to, particularly if you're a processor or you're a supplier for people, as to what your analysis of the laws are in the across the UK, as to whether or not that means that you can meet the requirements of the Schrems due diligence, and that obviously involves understanding security services access. If you can't put in place the safeguards which are in Appendix 2 to the European Data Protection Board recommendations. I mean, if you can and you fall within those, then that's great, and you need to do that assessment in terms of if you think you're going to need to rely on them to bring data into the UK. Do any of those apply to you in terms of the ones that mean that you can do it? If you can't, then the question is, can you do what you need to do without the data being brought onshore into the UK from out of the EEA? Can you use any of the derogations? As I say, they're pretty limited, so possibly not. And then, as you'll see, I've said there, if that doesn't work, what's your risk appetite? By that, what I mean is, these are not exhaustive, these safeguards. Do you think you can come up with something that potentially plugs any gaps if you think you can't? And are you happy to take the risk on that and to justify it? Certainly any decisions that you take, as I always say in relation to data protection, any decisions that you take, particularly risk decisions that you take, should be documented in case you end up in front of the ICO or another supervisory authority. And finally, in terms of finishing off the practical takeaways, you need to think about your representative and updating your documentation. I appreciate that's very much been a quick canter through. As I say, we did get thrown a bit of a curveball with the recommendations and the SCCs coming out over the last week or so, so we have had to sort of shoehorn them in. So we do have the Brexit Hub, which has got information on, as I mentioned, and finally we do have 2 events that are coming up, which is a private wealth summit with Brexit networking, and then also we are running bi-weekly Brexit webinars, and our next event's on the 2nd of December, which, as you'll see there, is cross-border civil disputes. Thank you very much for attending, very much appreciate it, and I hope it's been useful. If you would like to drop us a line with any questions we've not been able to cover, then please do so, more than happy. Thank you very much.